Good morning, everyone. This is Pooja Revankar from Sukhanidhi Investment Advisors. Sukhanidhi implies peace and patience, leading to happiness and satisfaction. Our company is a SEBI-registered equity investment advisory firm catering to equity investors with a long-term mindset. So today's presentation will be about individual estate planning by Ms. Nayantara Anjana Devaya. Nayantara is a graduate from Symbiosis Law School, Pune. She has expertise in estate planning and succession planning and have helped many people plan their estate and have specializes in corporate and commercial, private equity, venture capital, and laws relating to payments and financial technology, and have over 13 years of experience. Nayantara has contributed in Reliance Brands as in-house general counsel, in Reliance Jio as legal head North Region, and as associate in Khaitan and Company and in AZB and Partners. And at present, she is serving as a managing partner in Catkin Legal. Now, without further ado, we will turn the time over to Ms. Nayantara.
Thank you so much to the team of Sukhanidhi for that very, very gracious introduction. And I won't further delay. And first of all, thank you everybody for taking time out on a weekend, a Saturday, and being a part of this conference. I'm sure I will be able to add some value to your day. Like Sukhnidhi said, they are about peace and satisfaction, taking the route of peace and satisfaction. And this particular topic actually is a facilitator to that. So, what is a will? A will is basically a document that that a person writes in their lifetime to rights in their lifetime so that their assets can be distributed with ease after they're deceased or after they're no more. So there are a few terms. There are a few terms that we're going to be using in the course of this discussion, which I will just bring to your attention so that it's easy for you to understand. One is the testator. That is, in simple language, the person who is writing his will, writing his or her will. The other is the executor. So, in a lot of cases where a will is being written, a person who is trusted by the testator is appointed as the executor to execute the conditions of the will. This is obviously done, usually there are lawyers or financial advisors or somebody who's very close and a trusted ally to the person making a will who is appointed as the testator. The other word that we're going to be using is beneficiary. The people or the heirs or non-heirs who are entitled to the assets and sometimes liabilities as well in the will. So if a father is giving property to his son, the son is the beneficiary, the father is the testator. Then there's something called a codicil, which is basically like an amendment, an addition, an alteration to the main will. Testament, yeah, and a will is also sometimes called a testament, which in common parlance is basically a narration of what the testator is wanting to say in his will. Now, the main purpose of a will, like is to do what exactly? So basically, if a person does not have a will, whatever assets and liabilities that the person acquires during his lifetime is distributed amongst his heirs, either by a court of law, as per the relevant Religion Succession Act, or by a legal representative that is appointed under a letter of administration by the government or the court. A will also, in a lot of situations, what happens is people seeing, family and relationship harmony during the lifetime or during their lifetime, uh, don't create a will, and I've seen this in so many HNI and non-HNI families, where the person who is the main holder of the assets, the liabilities, is the main contributor, has actually seen so much of harmony amongst the family that they don't create a will. They leave it up to good faith and the justice of brotherhood for the assets to be equally shared, enjoyed, and distributed amongst the rest of the family members. But what happens in a lot of cases is, human relationships, when it comes to enjoying something, is one thing, but when it comes to distribution and ownership, is another thing. So, a lot of times, after the owner passes away, becomes deceased, there is a lot of dispute, discord amongst the family on the basis of for the distribution of property. And if there was a will, this would not have happened, or it could have been prevented, or there could have been other disputes, but the dispute over the division of property would not have occurred. So generally, a will is made in the lifetime of a person, and a will, I know, always talks about assets, but I, as a professional, have also seen liabilities like loans, properties under litigation, which are liabilities, being included in a will. Because sometimes what happens, while I'm stressing on liabilities, because sometimes a property under litigation, for example, I'm making my will and there is a property under litigation, and I choose to give it to my son over my daughter because I know that my son has the resources to fight the litigation in an appropriate way to make that property litigation free and then be able to enjoy the proceeds of the litigation. So, in my professional career, I have seen even liabilities being included as part of a will, which I think is a great idea, because just because the property is a liability doesn't mean it can't become free of liability, and doesn't mean that the fruits of the property cannot be enjoyed. So there are wills that have been created for assets, liabilities, and today, because of the benefit of digital media and telephones, and just how quick photography has become, it's become so easy actually to build pictographical or graphical representations in terms of annexures of things like jewelry, paintings, stamps, and anything that basically can be captured better in a picture than than described. And yeah, so to move on, a will usually is drawn up, drafted to prevent family discord, to prevent the law or the government coming and distributing the properties as per the Indian Succession Act, as per the level of heirs that are listed out in the meeting. I mean, sorry, in the listed out in the law uh, for the distribution of property. Now, what is the, this is like one relevance of a will, which is to avoid dispute. It is a mode actually seen by many as a mode of dispute resolution almost. Because if we have a will, there is a will registered in a proper way, recognized by the court, it can prevent a lot of dispute, litigation, save time, money, taxation. There are so many benefits of actually creating a will. The other thing is if we create a will, at an age where we have young children that are basically under the age of 18, it helps us appoint a guardian of our choice at that time for our children. And it helps us basically entrust them with the responsibility of caring, nurturing, and taking decisions for our children instead of, again, the intervention of a family court. Um, and those are the benefits of a will. Now, who can't make a will? So basically, everybody above the age of 18 can make a will. A minor cannot make a will. When does a will become null and void? If it is made under intoxication, if it is made under force, coercion, if there is no free will of the testator involved in making a will as far as the distribution of property and assets are concerned. And basically, in law, in the entire forum of law, there is something called free agency or the free will. So any circumstance or situation that takes away that free agency and that free will in creating a will towards the distribution and disbursement of property, uh, the will be considered invalid. We just discussed the advantages of creating a will, and they are listed here if anybody wants to go through right now. Oh yeah, one thing that I didn't touch upon that is, I think, very relevant today, what a person can also include in their will is, their last rites. And today there are so many ways, like things like organ donation. A person who by religion is supposed to have a burial but wants a funeral can say so in his will. So that is a very, very sentimental part, I think, that a will can also include. Further, a will can go through Further, a will can go through a lot of changes as and when you want. It has a format, but it is mostly written almost in essay type with annexures by the testator. When there is not a will, what happens? Basically, the law and the government dictates how the property should be divided as per Indian Succession Act. Now, why is situations when what will happen basically if there is not a will? We've discussed this briefly earlier. If there is no will, of course, there will be dispute. If a will is there and if a will is there and the person dies intestate, there is no question on how the property is going to be divided. So basically, we've just discussed a couple of situations here in terms of, and maybe this can be another discussion or another conference which will be relating more to the inheritance of property, will or without will. I'll just touch upon few instances here, but the basic ground rule of disbursement of property without a will um, is the next of kin. So if there is person A who has two children and a wife and he dies, uh, the property goes to his wife and then his children and then his grandchildren. So basically, in the Hindu law of inheritance, there are legal heir class 1, class 2, and so the law follows that. Now, the benefits of having a will is that person A doesn't have to give everything to his wife. He can divide it equally or in a proportion of his will as per, in a proportion to all his family members, his grandkids, his relationship by law, his children, his wife, even to a good cause like a charitable cause, or to another trust, or to the environment, to an environmental cause. So he really has the power to do whatever he wants, or to be able to actually distribute his property to any cause that he wants, to anybody he wants. Because if he does not have a will, it will only be divided as per the classes of heirs mentioned in the Indian Succession Act. And this is another situation. And the distribution of property. When a person dies, is basically how does it work, even if you have a will? So I'm just going to give you a basically a lowdown on the procedure that happens to create a will, one, and two, what happens once the person dies. Once the person dies, how do we execute or make the will effective? So the first step of making a will is actually drafting the will, writing up a will. So the details of the person, say me, Nayantara, uh, drawing up the will. So my details in terms of age, date, what is my current situation when I'm making it. It's very important, like I mentioned earlier, to be able to, to make a will out of free consent and without any coercion. So it really helps if this is mentioned in the will by the testator. Then a declaration of, that you're of sound mind, you're not under intoxication. That declaration just, I would say, adds validity to the will. The details of the beneficiary relationship, if they are not related by blood, why you feel that they should be a beneficiary to your assets, the executor of the will, the person who's going to make sure that the will is followed as it is written and as per the wishes of the testator, the relationship between the executor and the testator. There can also be a circulating testator, because in some very elaborate wills, it almost takes 5 to 6 years to actually execute the will. So a rotating executor, or a body or you can almost call it like a body of trustees that will act as an executor to the will. And of course, the details of the property, assets, and liabilities, we usually, as a practice area, we usually list these in an annexure so that it becomes just a lot more easier to read. So how we do it is we prepare an annexure with the beneficiary's name and all the assets that will be transferred to the beneficiary. So right from FDs, properties, liabilities, loans, positions in boards of companies, shares, everything is listed in the annexure. And the witnesses are very, very important. They should actually sign the document in the presence of the testator while the testator is writing the will. If there are any specific directions, this is to be given to the witnesses and the executor. Witnesses should not be beneficiaries to the will. This is a very, very important criteria. If the witness is a beneficiary to a will, it is considered invalid while giving the will sanction, which I'm going to talk about in the next couple of minutes. So a lot of times, what happens is if a person's making a will and a lot of the things, a lot of the transfers are happening in the name of the grandkids sometimes, and like say one or two things are being given to the children, the children become the witnesses. So that is actually treated as a malified intent. So witnesses usually should be somebody totally unrelated. Also, I would say it's best to have somebody like an employee, somebody from the staff, just to literally, as the word goes, witness that you are creating a will out of free will and in your breathing, living moments. Um, yeah, so the next thing is registration of a will. So I am specifically, going to talk about Karnataka, but because this is my state of practice and registration of documents is a state subject. That being said, I think as of the last 18 months, it is compulsory to register a will in the state of Karnataka. But earlier it wasn't. But as a ground rule to all my clients, any document that you need sanction and legal sanctity, have it registered. It is very, very important. What now most people do is they start thinking of wills on their deathbed or when they start, falling ill and they feel they don't have a lot of time left. Uh, and this is not the most practical way to go about it, because to actually go to a registrar's office or go to a government office when you're in your 90s, when you're ailing, when you can't even get up from a bed, is actually unfair on yourself and your caregivers. So please think about registering your will while you're still able, capable, and the registrar, there are situations where it can be, the registrar's availability can be accommodated, but it is not the most, it's not the most practical way to go about things. So the fact that you're creating a will to make life easier for your, heirs, just go the last leg and register it. And of course, the witnesses are required during registration. Um, so what happens once the will is registered, the person dies, deceased, what is, the course of action that the heirs are going to take. The course of action that the heirs are going to take is, basically they need to produce the will in a court of law, and they need to basically put in a probate application. So once the will is drafted by the testator, registered, the testator passes away. Now the will has to come into effect. So how do we do this? We put in a probate application. So basically, a probate is a certification by the court that the will can be executed, and it basically gives an order. It's a court order authorizing government authorities to recognize the will, the wish of the dead, and to change paperwork, etc., and cooperate with the heirs to transfer documentation as in the names as per the will. And let me tell you something, if you go the whole leg and you just put this probate court order in front of, say, a registrar who you have to do a khata transfer for. It makes the process so much easier. It cuts down red tapeism. It makes your paperwork easier. It makes ownership easier. So I would always advise people to go the complete leg of filing an application for probate, getting that probate court order, and then doing all their paperwork. And it is a very simple process. We just have to follow the process. The entire process has been provided for. Again, this application of probate has to be provided within 3 years of date of death. The court is going to ask you for maybe an affidavit saying that there was no coercion, original copy of the will, death certificate, and if there is a legal heir certificate. For movable property, this is how it works for immovable and movable property. But in cases where there is only movable property, a lot of the times the heirs go for a succession certificate. And that being said, I am going to quickly wrap up saying, please get a will done. If you are above the age of 18, it is extremely important. Don't start thinking of a will in your 80s. Registration becomes impossible. I have personally done registrations for ailing, aged people, and it is not easy for the testator, the caregivers, the lawyers, the government staff. You can basically make everybody's life easier with just writing a will. Go ahead, write your will. If you get stuck, my name is Nayantara. I am the managing partner of Catkin Legal. Come to us, we'll help you write a will. Thank you so much.
Thank you, Ms. Nayantara. We will go ahead and take some time for questions now. So whoever have queries can click on the raise hand icon, or they can chat in the chat box.
Okay, I can take that question. Yes, your question was, can a will be challenged in a court of law? Anything, any document, any situation, any person can always be challenged in a court of law. We cannot stop anybody from filing a case if they feel that they have a legit case. But yes, what can work for us is our defense. Now, when can will be challenged in a court of law? So this goes into the details of the property. Basically, there are two kinds of properties that a person has. It's either through generational wealth, which is inheritance, and two is self-acquired property. And this is more a conversation on, under the Transfer of Property Act and property legislations of various jurisdictions. So sometimes what happens is, of course, self-acquired property, for example, property that I have acquired in my lifetime through my earnings, I can distribute it as I want. But property that has been passed on to me as part of generational wealth, say my grandfather has passed it on to me, it has to be divided in a certain ratio and a certain section amongst my children and my grandchildren. So sometimes when people are not happy with that fragmentation or that division, they challenge the will. And the defense of the will, fighting of the case, the arguments depends on a lot of factors, the nature of the property and the relationship of the heirs, all of that. So to answer your question, yes, a will can be challenged. Any situation or document can be challenged.
Yes, any other queries are left?
If there are any more questions, I'll be happy to take them.
Okay, if any other queries are there, then you can mail us at
You
info.
aren't audible.
Hello? Yes, any other queries are left, you can mail us at info@sukhanidhi.in. So, Ms. Nayantara, is there anything else you wanted to cover before a wrap up? Ms. Nayantara, is there anything else you wanted to cover before a wrap up? ಕೇಳಿಸ್ಕೊಳ್ತಾ? Hello, am I audible?
Yes, audible now.
Yeah, Ms. Nayantara, is there anything else you wanted to cover before wrap up?
No, I think I've shared everything that I've had to. Anybody can reach out to me at any time. Please share my credentials. If anybody has any questions or requires any support with the will or any other property matters.
Thank you, Ms. Nayantara, for sharing your precious time and knowledge with us. And thank you, everyone. We appreciate you being here. And today's webinar is recorded and it will be uploaded in our channel. The link will be shared to all the participants. Thanks again for joining us today.
Thank you so much. It was an absolute pleasure, having this discussion with all the participants. Thank you very much for the opportunity.